I'm Kevin Lonergan. I work at the Herrling Clark Law Firm in Appleton, Wisconsin. My practice is plaintiff's personal injury litigation. My topic dealt with the integration of anti-stacking clauses in the Wisconsin statutes in conjunction with the drive other car exclusion clauses. We were talking about the interpretation of the new legislation that was passed by the Democratic legislature and signed by Governor Doyle back in 2009 dealing with auto insurance. I represented a family that was involved in a tragic accident several years ago, or actually a couple of years ago, where a mother was driving her 12-year-old daughter to their cottage. On their way, an uninsured drunk driver blew a stop sign at about 65 miles per hour and killed the daughter. The mother was injured as well. The family had insurance with State Farm Insurance Company. They had uninsured motorist coverage. They had a $100,000 uninsured motorist policy. They actually had two separate policies with uninsured motorist coverage. The insurance company tried to take advantage of language in the statute called the drive other car exclusion language to pay just one policy of $100,000 rather than the $200,000 that we felt that our clients were due as a result of the legislation passed by Governor Doyle. We filed suit, and we actually obtained a substantial judgment for damages against the drunk uninsured driver, and we also sued State Farm Insurance Company to try to take advantage of the uninsured motorist benefits. State Farm paid the first $100,000 but disputed liability for the second $100,000. Judge Conley in Marinette County ruled that our interpretation of the statute was accurate and held that we were entitled to collect both policies of uninsured motorist benefits, and we should have collected $200,000. The applicable law that was in place at the time of our accident was a law passed by signed by Governor Doyle, and it was a window between November 1st of 2009 and now November 1st of 2011. In 2011, the Republican legislature and Governor Walker passed legislation that reversed Governor Doyle's anti-stacking prohibitions, or the anti-stacking language. Historically, we would have recovered two policy limits had this accident taken place prior to 1995. The legislature changed the law in 1995. Between 1995 and 2009, we would have only recovered one policy limit. Between 2009 and 2011, we go back to the pre-1995 law, where we would collect two policy limits. Now, after November 1st of 2011, we would be back to one. Lawyers, of course, need to be vigilant, and they have to keep track of the changes in the law. Insurance companies now are arguing that during this period of time between 2009 and 2011, if you purchase two separate insurance policies, you don't get the benefit of the stacking of the languages. Claude Cavelli, who is my opponent in the case that we litigated, talked here at the seminar today. He is a formidable opponent. He can set forth the arguments that the insurance company is using to try to deny that coverage. And of course, I was able to hopefully successfully lay out the arguments in favor of that coverage.